What is a contract? Contracts are everywhere. They are central to the world of commerce, and many of us enter into multiple contracts each day as part of our regular lives. Bus tickets, petrol for the car, food, newspapers, most of these we acquire from third parties through contracts. But what is a contract? There is probably a temptation to think immediately of a written agreement signed by two parties. But think about the majority of contracts into which you enter. Do you write anything down? Do you sign anything? Probably not. A contract is simply a legally binding agreement, a voluntary assumption of responsibility capable of being enforced through legal action. And there are 6 key parts to a contract. There is offer, acceptance, consideration, intention to create a legal relationship, certainty, and capacity. I will touch on most of these in detail in subsequent podcasts. For now, I shall simply say that these are the 6 principles which are fundamental to a contract, and the absence of any one of them is going to mean that the contract is not validly formed. As such, one can simply say that a contract is something which arises when each of those 6 elements is present, and the effect of these 6 things being present is the creation of a relationship of obligations capable of being recognised by and enforced by the legal system. What forms can a contract take? As you will have noticed, of the 6 key principles of contract law, none related to the form of the contract. And, in reality, contracts can take any number of forms. Perhaps the most common contract is an oral contract, where you buy something from a shop, you hand over money, and they hand over the product. In other cases, you might expect a contract to be in writing, perhaps for a more expensive purchase, or when there is a lengthy list of things which need to be done to perform the contract. Other forms of contract are also common. There's a lot of literature relating to what are known as shrink wrap contracts for software supplied on a CD. You would buy the CD from a shop, but there would be a seal on the box saying words to the effect of, "By breaking this seal, you agree to the terms which are included in the box." Increasingly, contracts are made online, perhaps through clicking a button marked Order or I agree. If you've signed up to Facebook, for example, you will at some point have indicated your acceptance to the terms which Facebook showed you. Or if you use Apple's iTunes software and the web services which Apple makes available through iTunes, you probably had to click Agree to many pages of terms. We will consider later in the course whether clicking Agree to 50, 60, 70 pages of terms shown on a phone screen can really be considered to have indicated that a consumer has agreed to those terms in a legally binding manner. But online commerce is increasingly important, and there must be a mechanism by which would-be purchasers and sellers can enter into binding, legally enforceable contracts online, even if some particular examples seem to stretch what might be considered or appropriate. Perhaps the key principle to bear in mind is that, generally, there is no requirement that a contract must be in writing. There are a few exceptions to this general rule, with situations in which the law requires that certain activities can only take place through signed writing. For example, the assignment of copyright or the transfer of land. But these are definitely exceptions to a rule of very broad applicability. What this means is that the absence of a written agreement does not, subject to the exceptions, mean that there is no contract. You cannot safely work on the basis that something is not binding just because you have not agreed to it in writing. Nor should you necessarily accept someone's argument that the lack of writing means that they do not have to do what they are contractually bound to do. However, as we will discuss in the context of dispute resolution, while a contract need not be in writing to be a valid contract, having some form of agreed documentation as to the terms of the contract may be hugely helpful in proving a contract's terms. Reducing a contract to writing may be very important in creating evidence of a contract and its terms, even if not for the establishment or existence of a contract itself. You might like to think about this in terms of risk. If you were not able to point to a contractual document setting out the terms of the agreement, do you think that you would have problems enforcing it in the event that the party you are paying does not deliver? doesn't matter. If you're buying some food and you hand over your money and the vendor hands over the food, does the absence of a paper contract matter? You have your food, the vendor has their money, and the major parts of the contract are performed instantly. Unless, of course, you become ill from eating the food and want to make a case under contract law that what the vendor sold was not of satisfactory quality. But overall, the risk seems low. If you're entering into an agreement which is critical for your business, or which is complicated and requires careful performance by the parties, a documented contract may very well be a sensible approach. In this case, you might think of a written contract as a document of the agreement which you have reached, an objective reference for all the parties as to whom is required to do what and when. So to summarise, a contract is a voluntary assumption of responsibility which is capable of being enforced through legal action. There are 6 key elements. Contracts take many different forms and generally do not need to be in writing, although it might be wise, from the perspective of evidencing the agreement, in the event of a dispute.